business for this court during your due attention, you shall be heard. The God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session at the 5th District Court of Appeal. I'm joined today on the panel by Judge Sawaya on my right and Judge Lawson on my left. We have 3 civil matters before us, so the parties will have 20 minutes aside, and I will be happy to set the clock to reserve time for the appellant should you choose to. If you have a cell phone or something like that with you, we would appreciate if you would silence it so that you don't interrupt the parties. And we will start with our first case this morning, Southeast Unloading versus Lewis Lucas, when the parties are ready.
Good morning, Your Honors.
Good morning.
May it please the Court. My name is Nick Shaneen, and with co-counsel Kevin Jacob, we represent the appellant in this matter, Southeast Unloading. I would like to reserve 5 minutes of my time for rebuttal. Thank you. This, Your Honors, is an appeal about precedent, about the rule of law and the stare decisis principle that we as practitioners need to follow in order to practice our craft. And this is about what happens as a natural result when clear, uncontradicted, and binding authority is not followed by the trial court. Error is the result, and that is why we are here to bring the error before this court and to seek the reversal of a $6 million verdict that occurred due to a foot injury of Mr. Lucas. The reason that this clear, uncontradicted, and binding authority was disregarded.
What does the amount of the verdict have to do with the issues that we're supposed to resolve here today?
Your Honor, it goes to show that there was a harmful error. That if this were a de minimis verdict and we were here before you, certainly we would still have the right to argue.
If it was $1 million, would that make a difference? Or if it was $500,000, or where do you draw the line now?
It's a valid point, Your Honor. The $6 million is not the focal point. What is the focal point is the fact that Clooney v. Geating is the law of this state as applied through the state and federal courts of this state and is consistent with the widespread national rule on this same issue. And that is that a defendant employer who admits pre-trial to being vicariously responsible for its employee, who accepts that responsibility, cannot also be sued simultaneously on a concurrent derivative theory of negligence.
Mr. Shaneen, the issue that is causing me the most concern is the application of the two-issue rule. So why don't you give me whatever you think is your best argument on why the application of the two-issue rule doesn't sink your ship.
Absolutely, Your Honor, and there are several reasons why the two-issue rule cannot and should not apply to this situation. The first of which is that this issue was preserved for appeal well before it got to trial. In fact, no fewer than 8 different opportunities were afforded to the trial court to simply follow the clear and uncontradicted guidance of the second DCA, or binding precedent of the second DCA on Clooney v. Geating. And once the court decided on motion to dismiss and then again on motions in limine to disregard that second DCA binding precedent, the error was baked in. That when you appeal a matter, you're allowed to appeal those occurrences that happened before. And in fact, as this court's aware, a motion in limine, when it's clear in the ruling, need not be then followed up on additionally with the trial court. In this instance, trial counsel did follow up on it and continued to give the judge any and every opportunity to undo what is a clear error otherwise. And the trial...
I don't think there's any question that the judge was aware, as an opposing counsel were aware of the position that your client was advocating as it related to the vicarious liability and the negligent training issue, whether they could bring that in. My question, though, is at the end of the day, when you got to the verdict form, There was no apportionment between the two claims, one of which you concede is a proper claim, and one of which you argue is an improper claim. So for the sake of discussion, let's assume I agree with you as it relates to the propriety of the claim.
Sure.
My question, though, is we can't tell from the verdict form whether the jury put all of the liability on your client for vicarious reasons, for training reasons, or for some combination because of the way the verdict form was done. And I understand your argument that it would have been improper to do it the other way. But nonetheless, when you got to the ninth inning, that's the way things looked. So why doesn't the application of the two-issue rule say that we've got one proper theory of liability, one arguably improper if we accept your argument, and that's the end of the story? Although nobody can dispute that your client did everything but shoot off rockets during the trial.
Thank you, Your Honor. Your Honor, the reason why the two-issue rule still, even with all of that understood, would not apply is because, first of all, it doesn't apply to this situation, and second of all, even if that special, unusual, and incorrect verdict form had been requested, it still would not have undone the error that would have been built in, regardless of what the jury did.
Well, but we could have then understood the impact of the error. And I think that the two-issue rule is a rule of judicial economy, that if we can't understand whether the error, again, assuming that there was error,
Sure.
had any impact, then we're not going to assume it had an impact. You're going to have to show that it had an impact. And that's what I'm trying to understand is, how do we know that it had an impact?
And part of the answer does go back to Judge Savoy's question, why it is that in my opening I remarked about the $6 million verdict, that is part of the reason why that is relevant, because simply from the size of the verdict and the nature of the injury and the nature of the testimony, it becomes apparent.
How can that possibly tell us that this jury decided this case on negligent hiring as opposed to strictly vicarious liability? You weren't in the jury room, we weren't in the jury room, we don't know what the jury deliberations were other than they pronounced their verdict when they came out. So how can you tell me that the jury didn't decide this case strictly on vicarious liability and the dangerous instrumentality doctrine?
The answer to that, Your Honors, is that...
But because I'll tell you, the size of the verdict doesn't tell me that.
And I will concede that.
Okay.
I'm just trying to illustrate, though, the nature...
And I think that's what Judge Warfinger is trying to get you to explain. How can you tell us?
And
So that we can say there was error here, that this wasn't decided on vicarious liability only.
And the answer goes into, when you look at what that special verdict form would have done, the problem is if they did an improper verdict form where you actually separate out liability and add a blank for a derivatively liable party for the exact same negligence as the actual tortfeasor, if we had done that, regardless of what the jury assigns, first of all, the two-issue rule doesn't make sense here because the same error contaminates both parts of that equation. That first, you have the improper allocation of any fault to a derivatively liable party when they've already admitted to vicarious liability.
But wait, it seems to me that there are instances, even if Clooney is good law, that there are instances where you could be both derivatively liable and have independent fault. For example, if your driver, I forget his name, but your driver was driving his truck, he's driving fine.
Sure.
But your client hadn't told him, oh, by the way, the truck doesn't have any good brakes. And so your client is at fault for putting a truck out on the road with no brakes. They're liable when your guy runs into him. It seems to me that there are differences in the fault, and the jury would be okay in allocating fault between, was the driver negligent in the operation of the vehicle? I think the answer would be no. He didn't have any way of knowing that. Was your client negligent in putting a truck out on the road that had no brakes? Yes. So it seems to me that while it may be difficult, it isn't impossible to apportion. in the right case.
And I will agree absolutely, Your Honor, that in the situation of the brakes, negligent maintenance is not a derivative claim. Negligent maintenance, the Clooney case set out that exact
Negligent
hypothetical.
training isn't a derivative claim. The question is whether it's a proper claim in this case.
And Your Honor, to go back to that question then, when you set out the separate verdict form, the problem is that you have what we are talking about is in this case an improper derivative claim. So that part of the verdict form doesn't make sense. And the other part, the amount that they do attribute to Calvin Hill, who they were allowed to go after, let's say they had put all 89%, they draw an 89 on Calvin Hill and a 0 on Southeast Unloading. If they had done that, it doesn't take away the other error that's simultaneously done when you violate the Clooney rule, and that is the introduction of improper evidence. And it was that improper evidence that literally sunk the ship here, because that improper evidence allowed the jury to believe or to understand that just 2 weeks, 12 days, as is put in the answer brief.
How do you know the jury just didn't disregard that evidence? The jury has the right to say, we're not going to count that evidence. How do you know they didn't do that?
They may, Your Honor, and we, of course, can't know what a jury does, but what I'm attempting to explain here is even if we went with a special, broken out, and improper verdict form, we still don't know what we will be faced with.
Maybe it's easier to see in a negligent hiring claim, for example, if it was a driver that had a really bad driving record, and you split it out, was the driver reckless, negligent, and there was the victim who said, hell, you're sweeping everywhere, and the driver said, no, I was driving perfectly on that day.
Right.
If they allowed the negligent hiring claim and allowed the driving record to come in, even if it was separated out and they came back with 0 for the employer, that evidence of the driving record would not have come in if the trial judge had ruled correctly, and that could have been the reason why the jury decided to believe the plaintiff and not believe your client, and you just would never know. That's what you're saying.
And that's precisely my point. And that is, we believe, and I believe the evidence shows, exactly the error that occurred here.
But we're speculating here, right? We don't know.
We have to speculate, and that's the problem. This error has...
What is the problem with a verdict form that says, well, what is the liability, if any, for negligent hiring and retention? What is the liability for vicarious liability? And let the jury just say, is there liability? Yes, and if so, what degree? I mean, you're saying that, well, it would have been confusing, and it would have given the jury something that they would have been confused in trying to parse it out. But I just don't think that in this particular case you had any alternative. If you were going to claim there are two alternative theories of recovery, one was proper and one wasn't, then the jury has to tell you which one they're relying on. You can sit here and speculate all day that, that evidence may have affected their verdict, that evidence may have done this, that evidence may have done that, or you can speculate, as they probably will, that the evidence didn't have any impact. We don't know that unless we have a verdict that tells us. All we know is that we have a verdict that's presumed correct, and it comes here clothed with a presumption of correctness. And if we say that we don't know whether it was the jury relied on this evidence and based on negligent hiring or retention or simply vicarious liability, we have to affirm, don't we?
And the answer is no, Your Honor. You do not have to affirm. And the reason why is because in the other instances, and they're relatively uncommon in this sort of aspect. Normally a two-issue rule case is because of a faulty jury instruction or a totality of evidence situation. When we're talking about something like this where you both have a violative principle in the first claim and improper and potentially determinative evidence in the other claim, it makes it where the error occurs on both parts of the line. And that's simply not the case with any other two-issue rule case.
Let me ask a couple other questions.
Sure.
To kind of shift gears here just a little bit. We talk about Clooney. And you
Sure.
say Clooney is the law of the state of Florida. We don't have to follow it. We can say Clooney is wrong if we want to, can't we?
Absolutely.
Clooney doesn't discuss comparative negligence, does it?
Clooney doesn't discuss it, but it was decided after Hoffman.
So we have to, so you're saying now we have to presume that the court factored that in when they decided Clooney when we don't even know whether comparative negligence was raised as an issue in the trial below, do we?
Your Honor, it's not necessary for the court to solely rely on Clooney for that principle, in that the second DCA reaffirmed it in Muzio when comparing.
Here's the problem I have with your theory about Clooney, and that is comparative negligence specifically requires that any party with fault be allocated that fault so that everybody knows what everybody has to pay in terms of what their liability is. And if there's fault on the part of a defendant, they pay no more than their percentage of the fault. And I'm having a difficult time understanding how that is supposed to occur when a claim such as negligent hiring or retention is deleted from the verdict form and deleted from the jury's consideration. How is the jury supposed to determine what negligence the employer played in causing these damages? And I do not think that negligent hiring or retention is a vicarious liability cause of action. It's a cause of action for direct negligence against the employer. So that's what I'm having a difficult time trying to understand.
That very principle was the principle of Clooney, whether or not it's a direct action against the employer or whether, in the Clooney case, they attempted to have 5 counts where only 1 count was necessary, and the court said no.
Well, the court said that we're going to delete this count because the evidence that's going to be introduced is going to be too prejudicial. And I'm saying, yeah, the evidence is prejudicial because it shows that the employer was directly negligent in letting this person take over the control of the vehicle in the first place.
And the problem with that is, as the Clooney court recognized and as the cases across the nation have recognized, to the specific exclusion of the comparative fault argument, is that when you do that, you allow the introduction of evidence that would otherwise be excluded solely for the sole purpose of then trying to get the jurors to equate the prior actions of that driver to the current actions of the driver. 12 days ago...
That's not... If negligent hiring and retention is a cause of action, that evidence directly relates to that. And I'm asking you, I'm having a difficult time understanding why that's not a particular cause of action in this case and why it wasn't properly allowed based on comparative negligence principles. How do we know how to apportion the fault to the employer for letting this person drive if the employer knew that the person shouldn't have been driving in the first place?
Respondeat superior stands for let the master answer.
That doesn't have, respondeat superior doesn't have anything to do with whether the employer knew that the person was dangerous. That's not even an issue.
But Clooney has decided, and if this court wants to move away from Clooney and its 30 years of precedential influence on the state and federal courts here and elsewhere.
Well, I mean, I'm asking you to, I'm having a problem with that, and it seems to me that if we're going to comply with the comparative negligence principles as outlined in the statute and by the Florida Supreme Court, we have to say, what is the negligence of the employer in that particular cause of action? And we don't know if the cause of action is deleted.
The problem is, Your Honor, by doing so, you are allowing a plaintiff to unfairly bring in the host of prejudicial things into what should be a negligence case and the host of evils that will occur for this from a judicial standpoint.
Okay, wait a minute. But what does that have to do with the negligent hiring case? If it's a negligent hiring case and it's proper for the plaintiff to be able to plead it and prove it, that's certainly proper evidence, isn't it?
They're welcome to do a negligent hiring case and not pursue a direct negligence action. It just doesn't make sense to combine both. It's got nothing to do with comparative principles when we're talking about the same problem that Clooney faced, the same problems that Muzio faced.
So a jury instruction telling the jury you're only to consider this evidence for the negligent hiring cases, that's not... because we don't trust the jury to be able to follow the instructions.
A judge would be hard-pressed, in my mind, to consider that evidence for that claim and yet exclude it for the other claim when it's so directly probative on this issue. If he is accused, Calvin Hill, the driver, is accused of 12 days before having passed the test by fair, but then be described at fair as failing.
I just think it's, to me, I'll just be honest with you.
Mr. Shanine, you've got about a minute and a half.
I appreciate it. I would like to reserve that time for rebuttal.
Right.
Thank you, Your Honors.
Good morning. May it please the Court, my name is Chris Carlisle, and I'm here on behalf of Lewis Lucas. Your Honors, I'll turn to the two-issue rule first. There were a variety of questions raised over and over concerning why it should not apply in this case. And the only answer I think this Court was provided was that somehow, because the Court, according to their theory, allowed this improper measure of damages or this improper count to go forward, that the entire trial was impacted or tainted in some way, and therefore the prejudice was such that reversal was required. The problem is that before we get to that point, they have to get over...
Well, isn't the whole rationale under Clooney that evidence comes in that should not come in and would not come in if it was only the direct negligence claim against the employer?
Yes, Your Honor, I agree with you.
Given that rationale, if the evidence came in this case that could have prejudiced the jury in its consideration of the claim against the employee that should not have come in, how would the two-issue rule have helped that? How would we know if we had a separate verdict, whatever it said, that the jury didn't consider all this training evidence that arguably shouldn't have come in rendering its verdict with respect to the employee? Because
in order to get to that point, we have to know what the jury did. If the jury said 89-0 and attributed 0 for the negligent training claim, then potentially these are issues that would arise, and again, I'm speculating here as we all are, perhaps concerning the amount of damages, perhaps concerning some other aspect of the trial, but we don't get there. Their burden was to establish that the jury did in fact apportion some fault due to this claim that they believed should not have been before the jury. Once they established that, they were then able to argue perhaps that the prejudicial effect of this had some impact on the trial. But the first hurdle they have to get over is to prove to this court that there is an issue, that the jury did in fact use what they claim to be an improper claim as a measure of the damages.
Why
and
is
I think
the
it's
case
Judge Sawyer
reversible,
asked.
assuming that we agree that Clooney is still the law of the state, or is the law of the state? Why isn't the case reversible on the basis that the trial court erred in failing to grant directed verdict on the negligent training claim?
Well, Your Honor, again, we can discuss the aspects of Clooney, and I think that one of the things, preface to your question, is it the law of the state?
But let's just, for the sake of my question, assume that it is. We'll talk in a minute about whether it is or should be.
And you're saying that why didn't if the court...
Yeah. I mean, forget the two-issue rule.
Right.
If we say, well, the court, based upon the evidence before it, should have granted a DV on the negligent training claim. Why?
Meaning because there was a lack of evidence for that count to go forward?
Right.
2 points on that, Your Honor. One, as we mentioned in the brief, I don't believe that was really raised as a separate issue in this case. But assuming that it was properly raised before this court, we go through and point out the evidence that was before the jury. These issues were brought again and again and again to the trial court, including in post-trial motions. The trial court made a determination that the evidence was sufficient to go forward. There was evidence concerning these forms that were used. The person who was in charge of administering them said, I have no idea what poor means, what good means, what any of these other things mean. If he had given a poor, he would have had to have been retrained.
How do you translate that evidence into the argument that poor means failing?
Translated in that the lack of standards indicated that if he had put poor down, then their standards were that he had to receive additional training. And so the implication being that if he had been given additional training, perhaps that might have had an impact on what actually occurred here. When you have no objective standards and the people that are in charge of doing this say, we don't know what these things mean, then it is entirely appropriate for the jury to conclude that there was an issue here regarding training.
Well, how did you establish what the appropriate standard was to determine to what extent, if any, they breached that standard?
The appropriate standard was a reasonable person. This is not a case, and again, they raised the issue about OSHA standards.
But what do they know about, what does the jury know about the reasonable operator of a forklift in a frozen warehouse? There are certain things that are within common knowledge, and there are certain things, I don't know anything about how you're supposed to operate a forklift in a warehouse. Do you? Well, you probably do now.
Your Honor, again, the answer to that is the instruction that was given and the general negligence instruction that was given, the court had the ability to consider these issues. And yes,
That's why
I
we're
would
here. We're trying to
suggest,
decide whether they considered them properly.
yes, I would suggest that it is within the common understanding of someone when we have the testimony that was given here, whether it was, gosh, they never trained these people to take care when backing up, and this was an accident that exactly occurred when they were backing up. When you Yes.
I guess the problem I'm having in the context of this case, and I do think that there are cases where Clooney would not apply because there could be independent fault. My example before about the brakes. But in this case, you agree that once they admitted that they were vicariously responsible for whatever he did, none of the other causes of action that you alleged, in this case just the other one, caused any additional or resulted in any additional liability.
I disagree.
What additional liability could there be other than we're 100% liable for whatever our driver did that was negligent?
Well, here we are again. We're getting
How
into
can you be more than 100% liable?
You can't be, Your Honor, but here's one of the important things to recognize in this case. We're talking about comparing the various fault here. We have Winn-Dixie as a Fabre defendant. The remarkably interesting thing about this case is they're seeking to take Clooney and immunize themselves from their liability for training, which again is independent. It's not derivative of.
Well, but you agree that they could have been the worst trainers in the world. They could have hired a blind drunk to drive this. But if he happened to get lucky on the day that he was operating and didn't hit anybody, there's no cause of action. The only thing that gets you a cause of action is all of the things, which is including damages and liability. I mean, he's got to run over somebody. And so why he runs over somebody, I mean, it doesn't seem to be terribly relevant. But
Well, Your Honor, again, I think there's some confusion that exists in a lot of the cases and a lot of the jurisdictions talking about this, and that is the distinction between liability versus the actual negligence themselves or itself. Yes, the employer says, I am responsible for his negligence. But we're asking the jury here to apportion fault among a variety of people in this case, and we're saying we have potentially we have an independent negligent act on behalf of the employer that the jury is not going to be allowed to hear.
And but doesn't it have to be more than independent? Doesn't it have to be maybe an independent contributing cause? For example, they don't maintain the vehicle correctly, so the brakes are bad. That could be a contributing cause. So in addition to the fact that the guy maybe wasn't paying attention, the brakes weren't bad, so you can apportion fault. But for example, what if you had a red light, green light case, and the plaintiff says that the driver ran a red light, and the driver says, no, the light was green, and this guy just plowed into me, the plaintiff did. And so there's a dispute as to that. And then you allow a negligent hiring and a negligent training claim and tell the jury apportion fault. And like Judge Orfinger said, they could be the worst trainers in the world, and they should have never hired this guy. But if the jury comes back and believes some maybe overwhelming evidence that the guy did nothing wrong today, that the plaintiff is lying, and that the light was really, that the plaintiff ran the red light, if the plaintiff ran the red light and the driver did nothing wrong, then even if they fell completely below at the standard of care for training the employer and for hiring, don't you agree that they can't be liable for that?
I would agree.
Because it's
I think the proper way to think, I understand what you're saying.
Okay, so why would you give those issues to the jury and confuse them? They could come back and say 0 for the driver because we believe the 5 eyewitnesses that say that he had a green light, 50% for the plaintiff because he ran the red light, and these guys are the worst trainers I've ever seen in my life, and they never should have hired this guy. He had a horrible driving record, so 50% for them. What would we do with that verdict?
I think that you would have a serious problem with that verdict.
Yeah, but why would you give it to the jury when there is no independent contributing cause? It's just a sort of maybe an indirect cause. They didn't...
Respectfully, I think I disagree with that, and here's why.
So you say in that instance, if it's a red light, green light, you would give the negligent training claim to the jury and the negligent hiring claim to the jury?
I'm saying if there was evidence that was sufficient that they somehow did not train him on running red lights, etc., it potentially could get there. But I think the issue is this, and maybe where we get a little bit confused on it is It's not truly independent. Yes, you have to have the liability of the driver, which then creates the proximate cause or a portion of the proximate cause to hold the employer liable. It's not suggesting that they're not the same. The liability of an employer for its negligence cannot be excused and thrown away just because the driver was perhaps more negligent.
If it's a sort of an incidental or indirect cause, maybe the guy ran the red light because he wasn't trained right, or maybe he should have never been hired, then it still can't increase the liability beyond. The liability set at what that driver did on that day for the employer, it seems like, to me.
Well, again, respectfully, I disagree. You're talking about respondeat superior and saying the employer is responsible for the damages that the driver caused. Yes, absolutely.
So what you're in essence saying is, in my example, even if the driver was not negligent at all, you should still be able to apportion fault to the company that hired him?
I'm suggesting that
that really is what you're saying.
Well, respectfully, no, Your Honor, I disagree. I'm saying that as a prerequisite to finding liability on behalf of the employer for one of these claims, there has to be the negligence, there has to be the action that occurred on behalf of the driver. But there's a substantial difference.
How could he be any more negligent in running the red light because he wasn't trained right, or any less negligent because,
Well, again, Your Honor, because there's potential that when you're attributing fault, as Fabre, as the Supreme Court has said in Fabre and a variety of other cases, we have to look at all the circumstances here. And it can be...
Doesn't Fabre and the statute talk about apportioning fault to the parties to the accident, the contributing parties to the accident?
Yes.
And I have a hard time understanding how the training here... he either was or wasn't negligent when he ran over the guy.
And the driver's actions are
right.
Absolutely. And again, I'm
having a hard time understanding under Fabre how that liability changes any of the liability that they've already taken for the vicarious liability. Help me understand this. It seems to me, yes. You agree that Clooney represents the majority view in the country.
I agree that Clooney applies in a particular circumstance that is not applicable here. That most courts have applied the reasoning of Clooney more than others. But again, I think that to suggest that Clooney is inflated to this rule as opposed to being an evidentiary case dealing with that particular circumstance, I think is slightly different.
Yes. I believe that the appellants here cited the Gantt case out of Illinois, which I thought had probably the best discussion of why even in a comparative fault state it doesn't apply.
We cite the Lorio case, which is from, I think, Illinois or somewhere up there, which I think is a good discussion.
Lorio, if you follow it up, I think Gantt followed it up. They came back and they said, this isn't the rule. Well, a federal court said that, and a couple of years later, the same federal court said, we blew it in Lorio.
Well, I don't know if I would go quite that far, but I think, again, putting it in very stark terms.
Courts never really come out and say that. But they said they blew it. Come on.
Well, again, we can...
They came as close to saying I blow it as...
We can debate, precedent from other jurisdictions, and there's plenty of it in this case to be cited. But
you cited Lorio as saying that this is really a great case.
I'm citing
and
Lorio.
The reality is that Lorio, if it was ever a good case, if it had a stake driven through its heart, it certainly suffered death by 1,000 cuts.
Well, respectfully, Your Honor, I think the reasoning in Lorio was correct, and I think it's logical.
Well, apparently you're the only one, at least, that thinks that at least in Illinois.
Well, Your Honor, again, let's look at what actually...
Help me out here just a little bit. If the statute says we are to apportion fault of everyone that contributed to the or was a legal cause of the accident.
Yes.
And we have an employer that, and let's assume that in this particular case, knew that this person was not trained or the person didn't comply with the training requirements of the employer.
Yes.
And the jury hears that evidence. And the jury also hears the fact that the driver was negligent. Isn't the jury going to be more inclined to attribute more fault to the employer by hearing that evidence in considering the negligent hiring claim, as opposed to just hearing that, well, the driver was negligent, and therefore, because the driver was negligent, we're going to, attribute the fault to the employer based on vicarious liability. In which instance is the jury going to apportion the greater degree of fault?
Well, again, Your Honor, that we're speculating. I think the question is, and the fundamental question is, do they have the right to hear that?
Right.
Do they have the right to find that the employer
the point that I'm trying to make is that
Yes.
if we have the negligent hiring claim and the evidence is produced, and then we have the vicarious liability claim
Yes.
as well, the jury's going to, it seems to me, is going to be more inclined to apportion more fault towards the employer based on the direct negligence of the employer as it would be simply based on vicarious liability. That's the point I'm trying to make.
Perhaps.
Isn't that a concession that if the evidence shouldn't have come in, it's prejudicial?
If it shouldn't have come in, that it's...
Right,
Well,
yeah.
I mean,
Because you just said that because they heard this evidence, they're going to attribute more fault than they would have otherwise.
I don't know that. Again, I think that
Okay.
we're speculating on what might happen or what might not happen. But again, I think that the principled way to approach this case and approach the principles that were set forth in Fabry, et cetera, is everyone that potentially contributed to this has the opportunity to have the jury decide that. The jury can reject it. They can say, no, we don't think negligent training had anything to do with this. And for all we know, they did in this case, which is the two-issue rule. But secondly, how is it in any way fair or any way comporting with the principles of Fabry to allow Southeast to say, gosh, you know what? Jury's not allowed to hear anything about our negligent training, but you know what? We're going to bring Winn-Dixie in as a Fabry defendant. And we're going to say, you know what, jury? Look at what they did. And on page 3 of their brief, they say,
What was
accordingly,
the-
Winn-Dixie had a responsibility to both properly train its employees and to provide a safe working environment. So they're saying, you know what? We're immunized from our potential liability for training, but we're going to ask the jury to take some of our portion away and put it on Winn-Dixie because they didn't train properly. The principles of Fabry and the principles of the statute, it's standing on its head. It's creating an immunization for potential negligence on the part of an employer for no reason besides this fact that in a comparative negligence situation many years ago, that this evidence was potentially prejudicial in that context. That rule cannot be inflated to take the principles of the statute and the principles of Fabry and throw them out the window and say, you know what, employer, you can be the worst hirer or the worst trainer in the world, and we're going to immunize you, and never let a jury hear a word about that, while at the same time letting you throw somebody else under the bus. The point is, the whole has to come in before the jury. They're free to disregard it. The other side is free to argue to the jury, you know what, this negligent training had nothing to do with this, and here's why. And their evidence was skimpy, and it was et cetera, and blah, blah, blah. They can do whatever they want to do. But the point is to block it, to say we are not going to allow a jury to hear issues of negligence is frankly contrary to the rules and contrary to clearly established precedent. That's what's going on in this case, in its most simple form. Whether or not we're going to allow the jury to hear everything or not. And again, I think that Clooney, there isn't a case that we can find from Florida since Clooney was decided where they're saying, yes, we understand that we have contributory negligence now, and Clooney applies, and therefore we're throwing out these causes of action. Those don't exist, and I would submit it's
But
probably...
you agree that there's a lot of cases that have cited Clooney in the 30 years since then, and it hasn't come as a big surprise that we've got comparative negligence and Fabry and all this other stuff. I mean,
There are not a lot of cases in Florida.
you want us to assume that they just ignored all of that existing law when they wrote the cases.
I'm not suggesting you that we read the mind of what the courts were. I'm just suggesting to you that there is not a case that stands for the proposition specifically recognizing the principles of contributory negligence and saying Clooney applies in that context in Florida. And again, I don't know why that's the case, but you would think in the 40 years there might have been one if the rule was so clear and so definitive as suggested by the other side. Our position is Clooney makes sense in that context. It was primarily an evidentiary ruling saying in that type of circumstance, yes, we are finding, and Clooney even says, we recognize that the general rules of negligent training and all these other claims are legitimate. We're having a caveat in this case. We're saying that because the issue of the driving record could be prejudicial, we're not going to allow it. And we're saying we recognize this is an exception. There could be exceptions to what we're saying today. The point is, the exceptions clearly, in our opinion, became forth once the court changed to contributory negligence and once the statute changed. The reasoning of Clooney in its context perhaps makes sense. It was an evidentiary ruling. But to inflate it into a rule, to say that we're going to ignore the statute and ignore the Florida Supreme Court, I don't think you can read Clooney that way. I don't think you need to overrule it. I don't think you need to do it. I think it can be distinguished.
I'm
sorry?
In what respect does Clooney ignore the Supreme Court and the statute?
I'm saying that if you take Clooney and read Clooney as creating a bright-line rule that prohibits these cause of actions in all cases once we have contributory negligence, then I would suggest that reading of Clooney would be ignoring Fabre and the cases that interpret the contributory negligence statute. That's what I'm suggesting. Thank you very much.
Thank you. Hold on just a second. My negligent operation of the clock here has given you a new 20 minutes, but you got about 2 minutes left.
I will not seek to hold you derivatively or
That's
vicariously.
solely his liability, not
That's
ours.
right. They're vicariously liable.
You might not have trained them, I don't know. You're more senior.
Then I am going to adopt Clooney.
Right, thank you, Your Honors. Your Honors, a lot of points were brought up during the appellee's argument, and key amongst them is that, as this court pointed out, the Lorio decision was the only decision they could find nationwide that adopted the comparative fault makes the Clooney rule not a rule argument, and as this court pointed out, the Gantt case specifically took issue with Lorio, and then the Campa case of the exact same court that Lorio came
Well,
from.
I think what you have to do is go back and look at what the state of the law is in all these other jurisdictions in terms of what comparative negligence is. We have a comparative negligence, body of case law here in Florida that says you got to put everybody in there so that everybody's fault can be apportioned. And that may not be the state of the law in these other jurisdictions. I don't know. You have to go back and look at the case law and see.
I believe that the language in the Gantt case really gets right on point on exactly that issue. And as Judge Lawson was pointing out, it does not have a factual basis to add both of these people's liability together when all of the negligent training and all of the negligent entrustment.
We were talking about the evidence in this particular case, and I think the last line of questioning from Judge Lawson was, well, if the evidence was prejudicial, well, then that is even more compelling to say that reversal counts here. But if the evidence wasn't so prejudicial, the flip side of that is that then it would be harmless error, wouldn't it?
And that was, the evidence here was markedly prejudicial, that even in the answer brief itself, that pages 3 through 5, 9, 10, 31 through 34 are replete with examples of where they talk about.
So the evidence was really bad in this case, and it showed that the employer was really negligent in letting this guy operate the forklift when they knew or should have known that he wasn't qualified to do it. But yet, the jury can't hear that and apportion the fault relating to that particular evidence in this case.
The ruling, first of all, the evidence was substantial in its prejudicial form. It was not substantial enough to close the loop because they didn't use expert testimony. They didn't get OSHA standards. They didn't give the jury anything to hang its hat on.
Thank you, Mr. Shaneen.
Thank you, Your Honors. I appreciate your time.
Thank you both. Good case. Interesting case.